3.
Good morning. Thanks for joining us. I'm Mike Sams with Kenny and Sams, and I'm here with my partner, Drew Colby.
Good morning.
We are restarting this year our construction law webinar series. We did a number of these last year, probably about 10 different programs you can find on our website. As many of you know, Kenny and Sams is a trial law and risk management firm. We handle all types of civil disputes, business to business, shareholder disputes, a lot of insurance coverage work, a ton of employment law work for employers. But our biggest, or one of our biggest areas certainly, is real estate and construction related risk management and litigation. And so we find when we talk about risk management, we talk about helping clients with contracts and helping them deal with issues on projects. It may be counterintuitive coming from the trial lawyers who like to try cases and handle litigation, but we work hard to keep our clients out of litigation and trials. Sometimes you have no choice. Sometimes you get sued and you need to fire back. Sometimes you have no choice but to sue. And sometimes that's a good strategical step as well. But we really try to help our clients assess when that is the logical step, and try to keep them out of being sued whenever we can, just because we recognize that old adage, trials and litigation is no fun and nobody wins except for the lawyers, that can be true. Whenever you're in litigation, it requires you to pull your time away from productive endeavors, requires you to have folks working for you pull their time away from productive endeavors, and it certainly costs you money. So we do a lot of risk management work with our clients. We welcome you inviting us in to help you with risk management when issues come up on jobs, to help you with contracts, so that you know what you're getting into before you sign on the dotted line. And these programs that we've been doing are intended to help you with risk management. So as I said, when we kick this off, we've got a number of these programs that we did last year. Feel free to visit our website. They're there. You can find them and take them in. And this one will be posted to our website when we get done as well. Drew?
Yeah. So we're out and about. We spend a lot of time with the people in the construction industry, and we kind of hear what their concerns and complaints and issues are, and then we kind of tailor these programs to them. And one of the problems we've been hearing a lot of lately is bad contracts. You know, how do I get out of this bad contract? I'm in a bad contract. There are all sorts of issues. And these things can go sideways, and what I'm hearing a lot of how these contracts go bad is there's delayed starts, for example. Lending terms are more difficult now than they were not that long ago.
Can I jump in for just one second? And then I'll be as quiet as I can. Before we go down the path of how to deal with bad contracts, I think one of the things everybody should be thinking about, especially now when the economy is hot and you don't have to sign every contract, is don't do the bad contracts. And whether it's us or whichever lawyer you use, have your lawyers take a look at your contracts before you sign them. The notion that you can't negotiate on your contract is a fallacy. And it's a fallacy, I find, potentially for three different reasons. When the tier above you comes and is trying to sign you up, trying to buy out the contract with you, they need to get it done for one of three reasons. They've selected you because they think you're especially good, that you're going to get the job done without headaches and within the time frame, and they need you. That's one reason they're willing to negotiate. They really want you. Another reason they're willing to negotiate is your price was good. Now, you always antenna need to go up a little bit if they want you so badly because your price is so good, because you need to be concerned perhaps that you missed something in your bid. But sometimes you just did a really good job with your bid, and everybody else maybe was, because they've got so much work on their plate, was being a little bit piggish. So your number is particularly good. That's another reason they're willing to negotiate with you. The last reason that I find that the tier above you may be willing to negotiate with you is, like all of us, folks are really busy. And the contract may have sat on somebody's desk for a long time, and now things need to get moving, and they don't need to get moving in a month or 2 months or 3 months. They need to get moving in a week or 2 weeks. And the person in charge of negotiating your contract, the person from the tier above, responsible for negotiating your contract, doesn't really have the opportunity, time-wise, to bring somebody else on board. So you're it. And in those instances, again, practically, you've got a lot of leverage to negotiate. So approaching contracts as if, well, I've got to take whatever they put on my plate, absent it being a public job, in which case obviously you're not able to negotiate, is a fallacy. And I commend to you the thought, at least have your lawyers look at the contract to advise you of what the issues are. But I especially say to you, you'll be able to negotiate more than you think. Sorry, Drew.
Yeah, that's okay. So what we're hearing now in terms of bad contracts is delayed starts. I mean, that's a big issue. We're also hearing about price escalation. I'm in this contract. There was an interruption in the contract. There was, the separate contractors came in. They bumped me off schedule. The contractor took me out of sequence. And now I've lost my sequence, and this leads to lead time issues and approvals, et cetera, et cetera. So we're hearing a lot of buzz in the streets about bad contracts and how to get out of them. So initially, it's important to understand, what are some of these terms when you get a contract in that you should be looking at to see, is this one a bad contract or not? And to echo Mike's point a little bit, you are probably a lot more needed than you think. If they're coming to you, in all likelihood, it's because they need you, and you probably do have some ability to negotiate these contracts. The cheapest, most cost-effective, most prophylactic way you can protect yourself in the construction field is to revise a contract that's submitted to you that's unfair or unbalanced and tilt it more in your favor. So what are these clauses? When we get these contracts in, what are the clauses that we see that immediately jump out to us and say, this one could be a bad contract. This one could really harm whoever our client is at the time, whether it's the contractor or the sub or whoever. And one of the ones that I look at a lot is the unfettered discretion to change the schedule. And to push we'll use an example of subcontractor. To push a subcontractor out of schedule. To say to the subcontractor, I can interrupt your schedule at any time. I can make you refocus your work from one part of the project to the other. And we had one of these the other day. There was a concrete sub who was working in a particular area. They have to remobilize, set up in a different set, and they have to come back and finish the first set. I mean, these inefficiencies are tremendously dangerous from a cost standpoint to the subcontractors performing the work. So we look at these. One of the clauses we look at is somebody being able to control the schedule, to delay the start of the schedule, to change the sequence of the work in the schedule, and those are ones that really have a tremendous impact, particularly during a period of time of cost escalation and lead times. Those can be massively problematic. Another one is, one of the ones I always look at is approvals of submittals and approvals of requests for information, RFIs. You send them up the chain, they sit there, they lag up there, and nothing happens, and now your work is being impacted because someone didn't approve your submittal. We'll include often language that says, that the owner or the architect or whoever it is has to approve these submittals or reject them, or at least review them timely, and so as not to impede any of the milestones in the construction schedule.
Can I jump in for 1 second?
Yep.
On that point that you just made a moment ago about clauses that give the tier above you the absolute right to change the schedule, that has to be really disconcerting to you. And oftentimes we'll see contracts where there's language that says the tier above, whether it's the owner or the general contractor, has the absolute right to reschedule, and you have to respond to whatever their schedule is. And then there'll be a corresponding provision that says you recover no damages for delay. And Drew's going to talk about no damages for delay clauses in a moment. But one of the pushbacks on no damages for delay under the law is if the other side is sort of what we would call whipsawing you around the job. Hey, be over here. No, be over here. Be over here. Be over here. So that you're mobilizing and demobilizing and remobilizing, and having to assemble, in all different spots, such that you can't be as productive. What the law says, what case law says in those instances, that notwithstanding a no damages for delay clause, you may be able to push back on that because you're being essentially mistreated. It's sort of, I take it from the court that when those sorts of things are happening, the tier above you is breaching the implied covenant of good faith and fair dealing in a contract. The problem is that if you've contractually agreed with the provision Drew was just talking about, that they can do whatever they want to with the schedule, you've sort of ceded that argument. And so if you have a no damages for delay clause and you've given them the right to do essentially whatever they want with the schedule, you've in large part giving up your right to push back on the no damages for delay clause if they're mistreating you down the road.
Yeah, so we're going to touch on that in a little bit, but there's a distinction between...
Sorry, was I out of order?
A little bit. That's okay. The problem with the sequencing that we see is its inefficiencies, right? I mean, because if you have to mobilize and demobilize on a site, and we understand things happen on a site, right? It's not a straight line. They never are. There's always changes. There are always hiccups. There are always things that come on, whether it's a material that doesn't come in on time, a workforce that's underworked. We understand that there needs to be some construction scheduling flexibility. The concern that we have is what impact does it have on the contractor, right? Do you have a right to make a claim for delay? Do you have a right to make a claim for lack of inefficiencies or what's known as impact damages? In other words, we got our project done on time, but we had to work at night, we had to work off hours, we had impact type damages. So we look at those and say, if they have an unfettered right to change the schedule and there's no ability on the part of the subcontractor to get compensated either financially or time-wise for that impact, that's potentially very, very problematic. And it does tie into these lead times too. I mean, if you have to order materials, and you don't have a place to store them, you want to buy them out to get ahead of escalation, but don't know what the schedule will allow you to put them on the site. You might have a tight site where they don't fit. Those are the sort of things that get you into the bad contract. So when we look at contracts, we look at two things that focus or at least might lead us down to the road of a bad contract. One of these time issues that I just mentioned. And the other one is the damages. What are the damages that you're entitled to should issues arise in the project? And this is the no damage for delay clause. Specifically, a no damage for delay clause says if you're delayed because of somebody else, you're not in any way, shape, or form responsible for this delay. You're delayed because of somebody else. Your sole remedy in the event of a delay caused by somebody else is an extension of time to complete your work. In other words, you don't get your extended general conditions, you don't get extra costs associated with material procurement, et cetera, et cetera. That's a no damage for delay clause. We see them all the time, and when we're representing a subcontractor, we always strike them because they're just patently unfair to a subcontractor, particularly with a general contractor or owner maintains an unfettered right to change the schedule. We understand they have the right to change the schedule, but we have to have a corresponding remedy in the event that schedule is changed, and it has to be more than just simply an extension of time.
As long as you have not given up the right to the tier above you to completely control the schedule, there is case law out there that says even if you've been put in a position with a no damages for delay clause, again, sometimes you see them come up on public jobs where you have no right to negotiate, there is the ability to push back if they have been handling the schedule in a sort of bad faith way and throwing you all over the project. Even if you have ceded the right to have them unilaterally control the schedule, you still may be able to make that argument. It's just much harder.
Yeah, and the goal is to prevent you from being in that situation where you have to rely on case law to clean up a contractual term that's unfavorable to you. Obviously, in the holy grail in the construction world is to have a contract that protects you in advance of those situations, so that the remedy's built into the contract, so that there's no dispute, and hence costs and attorney's fees associated with trying to remedy a situation that was created, particularly one created by others. So some of the other damage aspects of contracts that we look at that are particularly problematic to us are obviously the pay if paid clause. If the tier above you doesn't get paid, even if it's not your fault, they have a right not to pay you. Most people listening to this will say, I thought that was done away with in Massachusetts, and it is, but only to a certain class of projects, and that's the prompt pay projects, the projects that are over $3 million. Those projects have a contractual remedy that voids those pay if paid clauses. But for anything under $3 million, the pay if paid clause is alive and well, and it's enforceable in Massachusetts.
Even on prompt pay, there's a
carve out.
A carve out where prompt pay, where pay if paid can still apply.
Yeah, but those circumstances are so limited, it's really unusual to see them. But yes, that's absolutely correct. The prompt pay does have a carve out for certain pay if paid clauses, but the category of
But generally,
opportunities for that to be used are very, very narrow.
Yep.
But on any private project that's under $3 million that isn't subject or subject to the Prompt Pay Act, those pay if paid clauses are alive and well, and they're enforced in Massachusetts. And they are extraordinary. Now, there's ways to negotiate around them, even keeping them in place. But we always look for those because those can lead to an extremely bad contract that someone needs to escape from. Another one that we see, Mike and I see a lot of this one recently, is the cost escalation clauses. What happens if material costs go up? There's a bunch of different ways to deal with that. But if you look at these contracts, a lot of them say, you own cost escalation regardless of whether it's a supply chain, regardless of anything, you own these cost escalations. And so we draft our contracts to try to work around those cost escalations to make carve-outs, exceptions. Well, the cost, we don't own all the costs, or we own them unless there's a jump in price of this amount. We'll buy them out as early as we can, but anything else gets subject to some sort of formula. Sometimes you can dump these costs into allowances or unit prices to protect that way. But when we see a contractual clause that says that the subcontractor or whoever it is that we're representing
or the general.
owns all cost escalation, that's a big red flag for us, particularly at this time. Another one is that the short notice clause. Like if you want to make a claim for extra work, you'll see these clauses that say, well, you have to let us know either at the time you knew about this change, or if you should have known about this change, and then you have to let us know within 24 hours, and if you don't, it's waived. And to let us know, you have to give us an exact cost of what this change is going to be, and this, then. In other words, they're making you give notice at a time when you don't have the information necessary to give proper notice. So what do? Wait till you get the proper notice and then lose your right to make a claim, or whatever. So we look at these notice provisions that deal with claims and the ability to make claims for extra work or pending change orders.
There's one other one you need to be careful about, and I've seen it pop up in contracts fairly frequently, and it has to do with the tier above you. Usually it's in the form of the owner's contract with the general, but it can be incorporated into your subcontract if you're a subcontractor as well, so you need to be concerned about this, where the owner is trying to shift over design risk over to the general, and then again by way of incorporation clauses, the general then sends it down to the subs, and it's in the form of language that says words to the effect of either contractor has carefully reviewed the documents and performed a diligent, not only performed a diligent review of the documents, but visited the site and warrants the sufficiency of the documents and can perform the work without further change. That sounds like a lot of blah blah, your eyes glaze over when you're reading it, but what it means is you're saying I can do this work and there won't be any change orders. Another way that you see that sort of language written is a revision to the standard AIA language that you'd see in a A201, for instance, that says, the contractor's performed a diligent review and has visited the site, but it is, the standard language reads to the effect of, but it's understood the contractor's doing its review in its capacity as a contractor and not as a design professional, and that the contractor will, if it finds any problems that it becomes aware of, notify either the architect or the owner. That's all good. Everybody wants that. If you think there's a problem, you should have to notify because you want to get it worked out before the work starts. But where I see the language getting revised there is it says, if contractor, it'll drop the language that says it's recognized the contractor is doing its review as a contractor and not as a design professional. That should make you raise an eyebrow. And then it will go on to say, and it's agreed that if the contractor knew or should have known of any deficiencies in the planning or drawings or specs, the contractor will be responsible for all related costs and damages for not having notified architect or owner. Knew or should have known. Well, if you've signed on to that contract, you have just invited the owner and the architect to respond to every one of your change orders with the rejection citing to that language. You said you performed a diligent review and inspection. You should have known there was a mistake in X, Y, and Z, and therefore you own the cost of the remedy. So that's another, the attempt to shift design responsibility down to the general contractor is something that the GC and the subs, because of incorporation clauses especially, need to be very careful of in reviewing the contracts.
Yeah, so, when we get these contracts in, we'll look at that kind of language and figure out a way to reduce some of the risk. And also to put more balance into the contract, quite frankly. Because a lot of times, another contract clause that Mike's alluding to with this design issue is, there's a document, the U.S. Versus Spearin, which basically says that if a set of plans and documents are provided to a contractor or subcontractor, they're entitled to rely on them and assume that they're accurate. You'll see a lot of language in these contracts that say, the owner or architect make no representation about the truthfulness of these design documents, et cetera, et cetera. So in other words, they try to say these things could be junk, but in your due diligence of reviewing the project before you sign the contract, you should have known that they were junk, and therefore you own any errors in the plans and specs. So we look for stuff like that as well. And we take that language out, because if something's given to you, you should be able to reasonably rely on it. I mean, if you see an error in it, you have to bring it to somebody's attention, that's fair. But if you don't know about something and you're not a design professional and they're trying to push this design risk on you, that can create enormous problems. I just was working on a case yesterday where we were a flooring subcontractor, and the GC is saying we have design responsibilities for applying a flooring surface on. And they're trying to focus on language in the contract, and unfortunately we didn't get the contract initially. The language they're focusing on is probably not sufficient to carry the day for them. But nonetheless, if you have this language expressly in the contract, we don't own design, and we're entitled to rely on anything that's given to us, you can get past those issues without getting involved in litigation. And that is what we're trying to accomplish with our risk management aspect of the practice, is to get rid of these risks so that you don't get into the litigation or arbitration phase. And again, the most cost-effective way to prevent these problems happening, the cheapest way, the best way to do this is to make sure somebody reviews your contracts to make sure that these landmines that might be buried in legalese in these contracts get reviewed and vetted out of these things before you end up signing them. And as Mike said initially, you'd be surprised how much leeway you'll have to negotiate these contracts. I mean, sometimes there's no leeway to negotiate a contract. It's take it or leave it. And I think that speaks volumes about the people ahead of you on that hierarchy. But in any event, that's the best way. So now we're going to get into, we've talked about some of the problems that get you into these bad contracts, and now we're going to talk about how to get out of them. And there's really two ways.
How to get out of the problems.
How to get out of the problems.
And maybe at worst case scenario, if you have to, because it is a worst case scenario, terminating a contract, how to potentially deal with that.
Right. And this
though I repeat, should be the measure of, it should be your last option.
Yeah, and the courts in Massachusetts and probably throughout the country, although I'm not an expert on what's happened throughout the country, are very, very crystal clear about this. Termination of a contract is a last resort. The courts will almost always look for ways to enforce the contracts if they can, and to punish people that don't terminate contracts correctly. So you do need to kind of dive into these contracts when a problem comes up and says, where are the terms, where are the conditions, where are the things that help me out? And these are some of the terms that we look at when we get a bad contract or a bad situation in, and say, okay, now how can we help? Where is the clause that allows us to carry the day a little bit on these things and try to push them into a safe haven, and instead of being under the thumb of an oppressive owner, contractor, whatever. And again, it's a lot of this comes down to delay, right? I mean, we've talked about delay earlier. We look at the things in the contract that say, if we draft a contract, it's going to say something in the effect that the architect and owner have to review submittals timely, and so as not to disrupt the schedule. So if we find we're behind the schedule and the subcontractor comes into us, or the contractor comes in when the owner doesn't approve things timely and says, they're really pushing me, they're really under the gun, we can go back into these clauses and say, they didn't do what they were supposed to do timely, therefore we're not at risk for what they caused. And I almost always throw in my contracts that from representing a contractor or a subcontractor, and we draft thousands of construction contracts, I'll almost always put in there that the subcontractor or contractor has no exposure to any delays caused by others. And that tends to be a very, very helpful one. So we look at these delay elements and we try to focus and see, okay, who else impacted your work, and was there a breach of contract or default under the contract in some way that we can then push back on them trying to make the consequence of their bad work habits at your risk. So we'll look at those. The other one we look at, is like separate contractors, like why are we off schedule, why are we inefficient, why are we working over here instead of working over there? And sometimes you'll find that there's separate contractors that are involved. Separate contractors are when the owner hires a contractor to do the work, you work under that contract, and they hire separate contractors to do a different scope of work. And this happens all the time. So in essence, there's two GCs, and who's responsible for that coordination. So we'll see if a lack of coordination at that level is causing the impact to the subcontractor on the job. The other thing we'll look at is like the owner's financial ability to pay for the project, right? If the owner has to make an affirmation that they can pay for the project, and all of a sudden you're not getting paid for change orders, your recs are getting held up, these things, and you go back to the contract and find out, wow, we can, under these circumstances, we can stop working until the owner proves that they're financially viable, and they don't. That gives you an out to protect you from the owner's conduct of not paying you or approving change orders or whatever.
That is and I see where we're at time-wise, but just to interject 1 second, that is a great provision to get in your contract when you're a general contractor negotiating with the owner. And frankly, the owner shouldn't be super sensitive to it. If they're well-financed to do a project, you should have the right. If issues start to crop up on payment, you should have the right under your contract to say to the owner, I need proof of payment, to assess, so that you can assess whether the owner is just being difficult or whether they're really running out of money and they're creating reasons not to pay you.
Yeah, so we do that. The AA contract says at the beginning of the project, you can do this financial viability test for the owner, and then at certain aspects during the performance of the work. We make sure that during the performance of the work, aspect of that is fleshed out in sufficient detail to protect us. The other support you might find is in statutes. And the prompt pay that we talked about earlier is one of them. If the owner's holding up your payments and you go back and you're looking at prompt pay and realize they didn't comply with prompt pay, that can be extraordinarily helpful to you. There's been recent cases that have come down and says owners and contracts that don't comply with prompt pay run a huge risk financially of a consequence for that. So if you're getting banged up on a project because you're not getting paid, and it's a prompt pay project, it's very, very helpful. In fact, it's necessary to look at the prompt pay and see if you can find any relief in that statute. And in fact, you might not only get relief, you might get remedy and actual significant damages from them for doing it.
Real quick, if though you are having problems with change orders or otherwise problems getting paid, preserve your rights. Most contracts provide a claims process, and we've talked about this in prior programming. You really hurt yourself, even if you're the good one, the good party in the dispute. If you don't follow the contractual process, you turn yourself into the bad contractor because you haven't followed the process. You significantly undercut your position. It may be salvageable, so don't give up hope. But especially in today's age where it is so easy to communicate by email and texts, even if we commend to you, follow whatever the contract says as the notice process. But even if you're not following the contractual process to a T, at least give some sort of notice about your claim. Emails, texts, somehow get the notice out and preserve it.
Yep, it's better to give too many notices than not enough notices. There's a case out there, the Providence Washington Insurance Company versus Beck, where somebody breached. The other party backed up because they breached, and the court turned and said you didn't follow the procedures correctly, so you're the one that breached. So you got to follow these procedures. That is so important. That can trump virtually any other issues on the project. You got to document position, you got to follow your contractual rights, and you got to make sure that you do what's necessary, what's called for under the contract.
And that includes if you get to the point where you recognize, I need to terminate this contract. I've talked with my lawyers, I understand the risks, but weighing the risks, terminating is the better one, is the better path for me to follow. I can't continue to go deeper and deeper and deeper into this. Make sure you follow the contractual mechanism for doing it. And that's what Drew was just talking about with the Providence, Washington case being an example. Most of your contracts provide a termination process. They provide a claims process, they provide a termination process, and part of the termination process will usually require that you give notice and the opportunity to cure by the other side. If you don't follow that process, you're likely, or you could very well be found to be in breach of the contract yourself, and you turn yourself into the bad contractor as opposed to being the good one.
Yeah. So we're running out of time. So I will say we have a bunch of new topics that are going to be coming up. That's the third Thursday of every month. We've got insurance, we've got employment, we've got prompt pay issues, we've got what does an OPM look for, an owner's project manager, how to make that work on a project. But most of our topics, quite frankly, come from people in the field that come back to us and say, this is an issue, can you address this? So if you have an issue that you'd like us to address, please reach out to us. We'll be happy to put it on the list, and we'll get to it as soon as we can. We respond to the industry. If they need to know something, we'll address it.
And if you have questions about anything we talked about today or anything else, feel free to reach out to us. We'd be happy to help you and appreciate you joining us.
Great, thank you very much.